Hello and welcome दोस्तों. Today we will discuss article 141. So every day 8 a.m. we are discussing one article of the Indian Constitution till the prelim. So it will be helpful for us to prepare for the prelims from the polity perspective, because every day we will cover one article. By that way we will be in touch with the polity for all these 4 months, and we will have enough base in the polity to answer each and every question. So from that perspective we are covering each and every article of the constitutions till the prelim. So do subscribe to this channel and do watch all this lecture, because this is small effort which can add a potential value to your preparation. So please do subscribe and do comment or like, because that will act as an appreciation, token of appreciation to my efforts, right? So let us start for the today's lectures. So today we will discuss article 141 of the constitution. Last time we discussed article 136, article 137, article 138. All these articles talk about special powers of the Supreme Court or special power given to the Supreme Court, right? So this article is also related with the Supreme Court, because India follows integrated judiciary. There is a hierarchy of courts where Supreme Court is at the top, right? So it means that the judicial precedent set by the judicial precedent, right? Judicial precedent set by the Supreme Court shall be the binding of all other courts in the Indian territory. So what does this mean? That all other courts means all other courts, that is including high courts and subordinate court of the India, shall follow the judicial precedent set by the Supreme Court. So this article is based on the principle of stare decisis. So what does this principle say? Is that while deciding any case, whatever the judicial precedent set in the last case should be followed in the similar case. So if there are similar case, you should see for the judicial precedent set by the higher courts in order to give the judgment, right? So this is the principle of decisis. Again, the binding precedent, that all the lower courts must follow that judicial precedent in the similar cases. So this ensures that there remains uniformity in the interpretation and the application law across the country, because India is a union, right? It is not a agreement of states that are governing entire polity. It's a union of, we follow integrated polity or integrated judiciary, right? So there is a limitation. So what is the limitation upon this article? That these precedents are not binding on the Supreme Court itself, because Supreme Court is the final interpreter of the constitution, final interpreter of the law, right? So these principles are not binding on the Supreme Court. Again, these only the principles of the law declared by the courts are binding, not the reasoning or incidental remark, right? So what does this mean? That principles are of general nature, they are generally applied everywhere, but not the decisions of the Supreme Court. So principles are binding, but not the decisions. So principles are general values, but decisions are based on facts and values, right? So every case has a different fact and different values. So based on Supreme Court will have decision in each case, but general principles of law is different, such as rule of law is a principle, right? So this is principle. Take for example, say last time Supreme Court scrapped National Judicial Appointment Commission based on the principle that it violates the independence of the Supreme Court, right? So that is the principle. Independence of the Supreme Court is the principle. So any law violating the independence of the independence of the Supreme Court should be scrapped, right? So that is all about this article. So what is the criticism of this article? This is rigidity and inflexibility, as I said earlier, because National Judicial Appointment Commission was the need of the time, right? But Supreme Court scrapped on the pretext that it violates the independence of the judiciary, right? Independence of the judiciary. So it seems like it has become a rigidity that there is no reform in the appointment of the judicial process, right? And the potential error, because it creates a perpetuating wrong legal principle, wrong legal principles, right? Suppose if judiciary, if the higher court of the judiciary is not giving a right to decide partner for the transgender community, right? So that is usually applicable across India. So it decides, it can perpetuate a wrong legal principle. Again, there is a democratic concerns in this, because usually what is article 50 say? Article 50 says there should be separation of judiciary and the executive. So this same principle goes here, because making law is a work of legislature. So right, so Supreme Court making law is a violative of democratic principle. So examples of how article 141 works. So if certain law violates fundamental rights, so all other courts must follow this precedent when dealing with similar cases involving that law, right? And High Court, while deciding any case, may rely on such principles laid down by the Supreme Court in a previous judgment dealing with a similar legal cases. So this law is important. So I want to tell you one important example. What is the difference between the legal principle and the legal decision? So here is a case that Supreme Court will rule that law requiring all students to stand for the national pledge in school violates their freedom of expression, right? So right to freedom of expression. So this is the principle. So any law requiring that a student to stand for the national pledge should be the violative of the this legal principle. So and this is the decision of the Supreme Court, right? So this is how this article works. So this was all about article 141. If you like this lecture, please subscribe and share these videos, and do follow every morning 8 a.m. as this will build your momentum for the upcoming prelim, right? So thank you.